First matter to come before the court this morning is State of Ohio versus Mohammed, Syed. Ordinarily, you would give instruction that both sides have 15 minutes to argue. The other side has waived oral argument. So you have 15 minutes to present oral argument. Please stay at the podium as we are recording this oral argument this morning. And it'll be posted on the court's YouTube channel. For that reason also, don't use the names of victims of crime or minors. I don't know that that's all that relevant to your argument today, but we like to make that advisement. The judges have read your briefs for ready to proceed when you are.
Yes, thank you. May it please the court. Judges, thank you for your time here today. Tony Dalianis, I'm here on behalf of appellant Syed. Adam is here today. He's sitting in the second row there. And I asked him to please not dress better than me, but unfortunately that did not work well. I've known Adam for some time, and I've represented Adam in a number of business dealings. Adam's family owns a number of the vending machines in town, so he's electronically inclined. We did present in the brief a statement of facts. I don't know if your honors want me to go through that in the argument of law, or if you want me to just present real brief what I believe should occur, and as there's a reason why, and then you can inquire if you would like. Okay, on behalf of Adam, I did present to him that the appellees, through their counsel, are well versed in the law. We're not here to argue any kind of a change in the law. We're not saying that somebody somehow applied the wrong law. And actually, in this case, we're not in any way, shape, or form disputing the facts of the case. In my appellant's brief, I did say, when does a grape become a raisin? And I said that in jest, because in this case, the question is actually, when is the information contained in the search warrant affidavit and a search warrant not a grape anymore, meaning a valid search warrant? Adam believes in this case that there were a number of issues that are specifically related to him that you could find as to why the search warrant did not meet. And I did put in my brief all the magic words and the decisions, and I did put in there the assignments of law regarding the competent, credible evidence, no indicative, reliable probability, that there would be no warrant of fair probability of evidence of a crime, and not to argue the law, but as the facts. We did file on September 30th of 2022 a copy of the search warrant and the affidavit. It was also filed with the trial court on the record on March 4th of 2021. I did also print a copy. If your honors would like, I could present you with a copy if I may approach.
Actually, let's just talk about any specific questions that the court
Perfect.
may have about
Thank
that. And I do have one.
Thank you.
Does it contain allegations that the neighbors had alerted the law enforcement as to unusual traffic? Does the warrant have that information?
Yes, very much so. And we're not disputing the fact that neighbors did call and present that there was cars and traffic in the parking lot. We're also not disputing the fact that there was a stop made down the road where a lady says, or somebody, we presume it was a woman based on the allegations in the affidavit, that she was fighting with a male at a gas station. So she had presented earlier on May 8th that she had won $500 playing cards. And that was the extent of the information contained in the affidavit.
Was there also information that, as it relates to the neighbors' concerns, that those coming and goings of cars were independently verified by law enforcement? Is that in the affidavit?
It was verified by the detective also at the search warrant hearing that they did independently verify. Unfortunately, they did not independently verify what normal traffic was at the home. They never in any way, shape, or form put on the record how many cars normally come and go from there. I, for example, have 5 cars myself. My son Anthony has a Jeep, that's 6. My son Gabe, I'm gonna buy him a car, that's 7. If my son's girlfriend's over, that's 8. If his friends are over playing pinball, which was also put on the record as an issue herein, then we could have 9 cars coming and going out of my driveway. So we believe that that in itself would not be enough.
In your circumstance, neighbors would be aware that that's common with you, that you have a large family.
Well, I don't really speak with my neighbors much as to how many of the comings and goings would be at any given time. I do help them out if a tree falls in their yard, but I don't think that in itself is indicative of a crime. It's just showing that people are coming and going from a driveway.
So in the affidavit, it was related that the neighbors had complained about a great number of cars going in and out. And then the officer that completed the affidavit, the affiant, he indicated that the traffic, based on their surveillance, was unusual. Is that
In
right?
his words, but there was no verification as to what usual would have been, is what Adam's issue is. So what is usual versus unusual? For example, I represented my friend Ted in a DUI, and they said he had slurred speech. Well, he had just had his braces tightened. So it's usual and unusual for slurs versus not slurred. But as it relates to Adam specifically herein, in the affidavit, the affiant, whoever's signing it, talks about a hearsay stop where a lady admits to another officer, which is an issue Adam has. Just because it's hearsay, you don't somehow make the statement more reliable when it doesn't verify it. So nowhere in the affidavit from the officer does he say in there that it's reliable, it's the veracity of it, the reliability of it. It's a hearsay on hearsay. It was another officer that did that stop. And that $500 that she says she won playing cards, which is very legal in Ohio. My mom and dad did it. And in fact, I asked the detective, I said, I have in my house pinball machines. I also have a dartboard. Can my kids, when they're over with their friends, play darts for money? And he said, yes. I said, can they win $500? I said, how about, I have pinball machines. Can they play pinball for money? And he said, yes. So herein, we don't have any kind of in the affidavit that Adam was taking any money out of the pot, that Adam in any way was benefiting financially. You know, this is a residence, so this is Adam's residence that got rated for a misdemeanor. Ultimately, the court held through the trial court, and the state didn't appeal that. So the standard is you rate a house for a misdemeanor based on people saying traffic's coming and going, and then a lady saying through a hearsay on a hearsay that she won $500 playing cards, because that's the best they had in the affidavit of the search warrant. The officer and the detective then says in the affidavit that he's signing this thing on the 8th, and that he's serving on the 8th. And the court, on the bottom of the affidavit, based on what the detective himself wrote, not Adam or anybody else, dates it on 5/12/2020. And it says not to exceed 3 days from the issuance of this order. Well, they went into his house on 5/9. So how does Adam, who's the defendant, somehow now handing the burden of, you know what, we'll fix any errors in here, and the benefit lies more favorable to the state of Ohio. But he gets the benefit of the view. The benefit of the view is how you read this. This thing is dated 5/12 and it says 3 days from. How do they correct that? They then say that somehow because this judge signs this thing on May 8th, but he searched him on May 9th, and he says in here that he searched him on May 8th, at what point in time does it become a reason? I don't file many appeals. I've been practicing law for over 20 years. The one appeal I filed was State v. Concilia, went all the way to Supreme Court of Ohio and validated half the DNA database of Ohio. I pick and choose which ones. There's a reason this happened for this appeal for me to file it. I believe when you view it in light most favorable to the accused, you don't give the state the benefit of the doubt of saying, well, it's a clerical error. The clerical error was done by the detective himself. And then he refers to hearsay stuff in there that has no veracity or reliability. Now, as to Adam, we ask that you find that the court lost its way when it applied the facts and there was no veracity or reliability of any crime. You're allowed to gamble for $500 in the house. The detective himself says that. And then I asked the detective, what's the difference between the inside of the slot machine versus the inside of a pinball machine, which you just said was legal? He said, I don't know. That's the best the state had. No other expert testified, nobody else linked, no other affidavit was filed, nothing. So the best you have is that you're gambling for $500, playing cards, which is legal, and then somebody played slot machines, which I didn't want to look today. You can buy them on eBay. How many you want?
Aren't those issues regarding,
As to whether there's a crime.
right,
He's signing an affidavit saying, I'm an officer and I'm signing an affidavit saying there's a crime being committed based on my knowledge.
but that I have probable cause to believe that there's a crime being committed?
Correct. So where's the probable cause if you're allowed to gamble for $500 and I'm allowed to play pinball for money? And he doesn't know the difference of the two. Now, you're gonna fill in the hole if you want for the state, but Adam's saying when you view the light most favorable to him, on this case alone, you shouldn't do that. They didn't present that anywhere on the record.
What if one of the witnesses had indicated to the officer that not only had they been playing cards, but that the individual that owned the property had 10%?
Then we have a problem, because now he's doing it for profit. Because my mom and dad.
I'm sorry, so what I want to follow up on is then if the affidavit itself contained that the informants had indicated that the property owner was keeping part of the money, part of the pot, then that would have been sufficient?
I believe so, because now it's for profit, versus just you're hanging out and you're allowed to. Ohio allows us to, and especially Ohio under MAP says we have more rights than even federal. So why would you ever then fill in the hole for the state? You shouldn't. They messed up. They should have done their job if they believe that somehow Adam was violating the law. The other issue I have is because I have 7 pinball machines and I don't know how many arcade machines, arcade1up.com is now selling slot machines online. So all those people getting them in their houses that are going to be playing, they're allowed to play, they're allowed to. Their house costs a lot of money to be there. They're not maintaining that house for profit. That arcade1up machine is coming to the house, and Adam here likes to build them. It's his hobby. What happened in my life is I bought 1 pinball machine, then I woke up with 7. That's what happened. So when you had a room full of them, that's what we do. We're hobbyists. So how did this guy differentiate hobbyists that are playing in their house versus a crime? Adam gets the benefit of the doubt, not the state. So he has asked that you please send the case back, suppressing the stuff that was taken out of the house. He was charged as a felony. The court found it was a misdemeanor. This is a misdemeanor we're talking about. I don't want an officer coming through my house door, kicking it in because my kids are playing pinball between themselves and there's no officer that knows the difference between anything. So we ask that you at least kick it back down and let us move on as it relates to the misdemeanor. The state did not say we didn't preserve that right. We did preserve it everywhere on the record that we, even when we entered the plea, we preserved the right to be able to come back down if we found so. So we do thank you for your time. If there are any other questions, Adam also thanks you. And we took a tour downtown. I took him to a courthouse. It's been that long since I've seen some of you, and I thank you again.
Thank you, counsel.
Thank you.
Court will take a matter under advisement. We will issue a written decision, which will be sent by the clerk of courts to all parties to this appeal, as well as posted on the Ohio Supreme Court website.
Thank you.